And we can start recording. Good. Okay. So I'm sorry that I wasn't able to be in the last meeting. I know I wasn't alone in missing it. Andrew, I think you were out of town or not available also. And thank you, Stephen and Dave and others for soldiering on. We don't have a big agenda today, but I do want to talk about the pretrial services concept and the pretrial services department, and or I guess unit is what we call it, and where we're going with that. Judge Freeman, do you have any updates for us?
I don't think so. We are. Can everyone hear me all right?
Yes.
Okay. My office computer had a complete meltdown, so I'm out on the bench, and it's not usually set for this type of setup. We have been in the process of hiring for the pretrial services manager position. Unfortunately, we also had two other positions that we've been hiring for in the last month. So most of August was spent with interviews for all three positions. And, you know, there haven't been any final decisions made essentially on that. So I don't believe I have any updates for the group.
Okay. Carol, thank you for the articles that you asked Jill to send us and that she did send us. I don't know if the rest of you had time to read the article. It was actually one article, but it described 5 different courts and how they treat pretrial situations, especially those involving domestic or intimate partner violence. I was impressed with several of the different measures that various courts do for their pretrial services, including but not limited to domestic violence situations. And I'd encourage all of you to read the article if you haven't already, because I think it has some good ideas for things that we might do, or at least try. One thing that I was impressed with too is that several of the jurisdictions in the article were as small as we are, or perhaps smaller, and yet they seem to have more resources than we have. And that to me sort of underlines the need for us to A, preserve the resources that we have in the form of the pretrial services unit, and B, explore ways that the pretrial services unit can work actively with other agencies that help people pretrial. So enough on that subject for now, but please, if you haven't read the article, read it, because I think it has some good inspiration for our group as well.
Judge Garrett?
Yeah.
How do you see us doing something with Carol's article, or with the questions that it raises? I mean, what after we read it, what might we do next? Or Judge Freeman, I guess, also.
I think one of the things that, I mean, our work group has not been real active over the last year or so. You all know that. And part of it is we're still catching up with our statistical lag, and, caused in part by COVID and other situations. But part of it is too, we're sort of in a transition. What I see the pretrial services unit doing, at least what I hope for it, is that pretrial services can be more actively involved in helping defendants not only stay out of trouble and come to court, but get matched with services that they need to improve their lives and their criminal histories, or their criminal presence, I guess. And that's, I'm glad to see connections being established, which have been established with the LEAD program, for example. In a couple of these jurisdictions, there are actually teams of people who have mental health credentials rather than legal credentials, who work with the pretrial services unit in the court to assure that that people are headed toward the right resources, and also to help supplement the pretrial risk assessment, which a number of them use, the Arnold Foundation one, the same one we use, but to supplement it with expertise in intimate partner violence and dangerousness, which, boy, wouldn't that be great if we had, if that was a part of pretrial services? And so the work of the Alan and his colleague in that department could be expanded to, you know, to those kinds of services. I was just very impressed. That's one example. There are several. And if you read the article, as I say, you'll see that different jurisdictions go about it different ways, but there's a heavy mental health influence in the whole picture. I don't know if that begins to answer your question, Stephen.
It does, and I think it points us toward thinking about this as a potential action item that I don't know if we would get to the point of making recommendations, and if so, whether they would be to the judicial officers of Superior Court only, or to the county council for staffing resources or what, but it seems like it would put us on a more active path than an analytical one, which we've been on.
Yeah, I agree. And I don't know if this is the time to say it, but there has to be said at some point. There's a jail initiative on the ballot, as you know. I think there's a good chance that it's going to pass. That means that our current jail situation isn't going to change in the short term, because it takes a while to build a big facility. But once that facility is built, the pressure on judicial officers that when in doubt, lock them up, is going to really increase. And at that point, pretrial services is going to be really essential, because we'll be dealing with situations where there is the potential to lock the defendant up. And, you know, judicial officers are under a lot of pressure to do that when someone has, you know, committed some kind of crime or appears to have committed it. And anyway, if there's more room in the jail, there's more need for pretrial services, I think. So I want our committee to hold on and render meaningful services now, so that when we have a bigger jail and incarceration is much more of a potential for even minor crime defendants, that we'll be well positioned to offer an alternative. So that's my vision for us for the short term and then the long term. I think our program has been halted or has faltered for a couple of reasons. One of them is personnel. We have not had an active or proactive, I guess, pretrial services leader for quite a while. And Alan has been doing, I think, an excellent job of covering all the bases he can. But with simply one person, it's not going to be possible for him to forge out in new directions, make new connections, do the kind of proactive merging into the community scene that we've envisioned for pretrial services. And so I'm really looking forward to having the pretrial services unit fully up to speed, so that some of those things can start to happen again. And like I say, I think it's pretty essential, because these jail restrictions are not going to go on forever. And so, you know, the potential for incarceration is going to be there, which may be a great thing for the pretrial services program, because it goes back into the incentives people have to stay out of trouble and comply with pretrial services. I'm sorry, I don't mean to give a big speech about that, but that's what I see for our committee, our work group, in the relative short term and the relative long term. And I'd like to see us now building a structure that we can build on as the jail gets, if there's a bigger jail, the need for pretrial services is going to be bigger. And if we have in place a structure that we're using now, relationships with various community groups that we're working with now, it'll be much easier in the future to build on that. And so as the need gets bigger, in that the number of defendants being served is bigger, we can be in place and ready to move ahead on that. So that's my vision. Sorry for talking so long.
I'm just going to jump in for a moment as far as what we have been doing with the part of our target for the supervisor position is our interview questions, our application, everything had to do with growing the program and creating outreach with the community and being a point of contact. So it's not only simply getting them to court, but also giving them the resources if they would like to use them. Obviously, we can't order them pretrial, but making them pretrial a point of contact so that they can access those services. Alan's been doing a great job, taking the initiative. He's brought up, and the judges have approved it at this point, creating either a Facebook site or a website for pretrial services where he's going to be able to do more outreach, also get our calendars out a little bit more accessible so that people can just look at a Facebook page, hopefully. So I think he's been doing a good job of that. That's short term, I think, where we're targeting pretrial services to go. I've also had some luck with Alan and with I'll say some creative solutions that attorneys have brought. Alan's been willing to do some minor monitoring of certain things as far as compliance with when attorneys have agreed that somebody will, let's say, do drug and alcohol treatment. Alan's been willing to monitor that to some degree. I wish we had somebody from the prosecutor's office on this. I see that we have Maya on the call. One area that I would like to explore in pretrial is the ability for essentially creative solutions between the parties. The bench is limited on what we can order, but oftentimes we get presented with what are called stipulated orders of continuance, where it gets continued for a year, and sometimes usually it's just no new criminal offenses during that year. But I'm wondering from like Maya's perspective, whether if the bench could offer through pretrial services some level of monitoring with aspects of treatment or something of that nature that doesn't require the full recovery court type situation, whether that might open the prosecutors up to more alternative resolutions that don't require a conviction.
Well, pretrial is really tricky for us. We have behavioral health specialists, just 2 for all of the defendants. That's, I think, woefully lacking. But we do try to set our clients up with services in the course of negotiations, but it's voluntary and it's woven into a strategy for their case. And I think that's more appropriately done with using the behavioral health specialist support, social work type folks in our office when it's pretrial, because we're sharing information and we really are working closely with our clients in that way. That's how I see it.
I guess my question is, though, we see weekly, we have 2 or 3 stipulated orders of continuance get entered. And right now they are very limited on what they can require because we don't have a monitoring piece to it in Superior Court. Would the state be more willing to offer those stipulated continuance if there was a monitoring piece?
No, I mean, usually, if they're going to offer an SOC, which they are, they're not super common ways to resolve them. We would like to see them do them more because it results in the dismissal of the charge. There are often conditions in there, must comply, like comply with mental health medications, comply with mental health treatment, get a substance abuse assessment or something. Those are, when appropriate, in there. I mean, sometimes they're just remain law abiding because that's all that's needed. So I mean, I don't think it's for lack of creativity that we're, I don't think there would be more SOCs if there could be more conditions, because if we think there are conditions that would convince a prosecutor to give an SOC, we are doing that. It's, they're not giving them, or, I mean, they are monitored, like we set review dates on some of them if there's restitution to be paid, which is also another common requirement on an SOC. If I've seen ones where it's like, if they have to comply with mental health, they'll set a review date midway. If it's a 2-year SOC, they come back in 1 year to see where they're at. Maybe they get, I don't know. I guess I don't see that as expanding SOCs, but maybe a prosecutor would see it differently.
Okay. Like I said, the court has very limited means as far as what we can impose pretrial. And where I see that some of this is, if it's going to move the needle as far as the state offering these alternatives, I would rather see the resources go there, because oftentimes someone might not qualify for a therapeutic court or may not need it, but may need a level of supervision that we can't currently offer. Sometimes, as Maya said, what the parties will do a drop down on part of the charges in the district court in order to get the monitoring piece, and we can do it that way. Sometimes that option is not there, so we either don't get the SOC, or I see it more often that, on very easy cases where there wouldn't be monitoring, essentially, or wouldn't need a treatment prong. So I would like to hear from the state on that one as well. It's kind of a smaller step without opening it up to a full-blown treatment court, because technically those cases are still in pretrial status.
Well, Dave, is that something that you and Eric Ritchie and Maya's office could talk about outside this group and try to get, some official participation by the prosecutor's office?
I can certainly reach out, and Maya might be right that it might not move the needle at all on that. I've had a couple of successful with Alan being able to work. One was a very true pretrial situation where it was basically a lesser restrictive alternative, and the parties were in agreement with it, so we were able to execute it through Alan. And then so I see some potential there. It would have to be by agreement with the parties. This isn't something the court necessarily is all that involved with, but I would like the option to be there if it might resolve some cases.
Well, can you give the example of what was the less restrictive alternative that was agreed on?
Yeah, it was, my recollection was it was an alternative to bail because the person was engaged in some sort of substance abuse treatment. And I don't want to get into too specific, and I'm sure Alan knows the exact details because he's monitoring it. But the parties agreed to the monitoring aspect of it. And all it was showing Alan proof that that was continuing to happen. It didn't require Alan to be, checking in with treatment all the time. It was fairly minimal.
Okay, thanks.
If I could jump in with two thoughts, sort of in response to that dialogue Judge Freeman and Maya just had. Number one, I'm noticing a pretty regular lack of participation in this work group by the prosecutor's office. And I'm wondering if, Judge Freeman, if you talk to Eric again, you can sort of touch base and encourage a little more participation from that side, because it seems like a lot of the topics we touch on, we're tremendously fortunate to have Maya's time and perspective on this. But just to balance that or be able to evaluate pros and cons, it would help to have a prosecutor's perspective as well. And it feels like we might be a little stymied without the kind of participation we used to have some time ago. So that's my first thought. The other is I've always liked the idea of having behavioral health specialists in public defender's office. That seems, and maybe I don't understand it, and maybe a presentation on the exact role that those staff members have would be beneficial. But my sense is that's focused on case resolution from the PD side, as is your suggestion, Judge Freeman. And I like the idea, you know, we're beefing up the reentry staff in jail, which has a connective behavioral health kind of benefit that's more general to the person. I would like to plant people with some behavioral health expertise at different points in the process. And even having a behavioral health specialist in the pretrial services unit, not necessarily focused only on DV or IPV, but that seems to be a model that has adopted that. That might be a way to deal with compliance with release, to make that more successful. And I don't know. I mean, that seems like a direction I'd like to see us exploring as well. Is staffing out not just the one hire we're thinking to work with Alan, but thinking about expanding the scope of what pretrial services could actually look like.
Was there any follow-up with the person who came and talked to us about intentional flight?
I've had some minimal contact with her yet. Still, I have not posed. I think you were not at the last meeting.
Yeah, I was on vacation, I think.
There were a lot of concerns brought up by the bench when I brought it to the full court, and I shared all the information provided by Megan. I have some formulated questions. I have not passed them all along to her yet. It wasn't necessarily pushback as far as the goal. It was the fact that implementation would be, in our eyes, very, very difficult, especially in a single jurisdiction like ours. So that's the concern.
I mean, it seemed like they were looking for a jurisdiction of our size, and that they were equipped they would have a staff person who would be tackling that data collection and analysis part. Like, it wouldn't be something the court had to do. So I would be curious what the follow-up questions are and what her responses. I don't know.
That's one of them right there, is how the data would be collected.
Yeah.
When we met with her initially, and what I responded back to her is that I'm still interested in being involved as far as the data collection. I'm not sure I have a full agreement with the bench on that, but even data collection, there was pushback as to how that would occur and when it would occur. As you know, we certainly don't want to be adding additional time in court calendars, and we were concerned. We often see, you know, even warrant quashes come by way of agreement of the parties sometimes, and so we're not sure what that would look like.
Okay, well, if you pose questions and get answers that you think could be illuminating, I'd love to hear that, see the responses.
Yeah.
So I guess this changes the subject a little bit, but Andrew, I'm wondering where you are in the ultimate compilation of all the data that we've given you over the years.
Thank you, Judge Garrett. Good afternoon, everyone. I think I'm still waiting for more from my boss. Has a letter been sent to him? Is that brought up a couple of months ago?
No, I don't believe it has, and
Okay.
I'll work with Judge Freeman to get that out.
Okay, yeah, because I just need from here, because the size of the project, I just need authorization from him to get going on it. So, you know, I've been kind of prepping, and you know, as data updates come to me, kind of getting them ready so that, you know, I can get the ball rolling once that gets in place and I get word from him on you know, where to put the project, how to prioritize.
All right. Dave Freeman. I'll write a draft letter and send you the draft, and I think it should go out over your signature rather than mine,
Okay.
but it could go out over both of ours if you'd like, but I'll take on the draft and get it to you.
Okay, that sounds good.
Okay. Okay. Anybody else have anything they'd like to raise at this point? And well, let's explore that first. Anybody got a comment on any of this?
Not on the data collection. I do have one other point I was going to bring up with this group. The court has been quietly working for quite a while on what to do with contempt funds that end up being collected, and we have been brainstorming, and I think we're getting to a clearer picture of how we want to apply those. And I'll be reaching out to the behavioral health committee on this. And I'll probably have Judge Brockmall present, because she's been the one meeting with the executive. But I can say at this point that in general, we're looking at applying those funds to some sort of guardianship program locally, hopefully targeting some of these civil flip cases and making them accessible for folks that clearly need some support in the form of a guardianship but aren't currently getting it, and no one on their behalf is there to file. So that is our hope as far as where these funds will be targeted. It's a little bit tricky on how involved the court will be in that. But I think Judge Brockmall has been working pretty closely with the executive at this point, and we at least have an idea formed. And I think within the next month or so, I'd like to share that with the behavioral health committee before we take it up to any further, just to keep people involved, because I know there have been questions at the full task force level in the past about what's going to happen with that contempt money that's come in.
And I'm sorry, my audio clicked off just as you were saying, what's the source of these funds?
It's the contempt for the failure of the DSHS, the department, to timely transport defendants.
Yeah. Oh, it's all those fines we levied and all the contempt proceedings. They're finally paying?
They're paying. We're still formulating how to get judgments entered on that, and we've been working on that behind the scenes, and we've identified the majority of the funds that are out there now. Each department has identified cases that are assigned to us. We know what's out there that needs judgments. We're still working out the procedure on what that will look like. But this has been discussed for quite some time. I just didn't feel comfortable talking about it publicly yet, because we didn't really know where we were going with it. We hadn't made any final decisions. I wouldn't say this is final yet, but this is the idea that we're putting forward, and we're hoping we get some support for it. We've seen some successes with guardianships in types of cases like this, where, you know, DSHS has become involved because somebody has become hospitalized, either on a commitment case or for health reasons, and they've been the ones to file for a guardianship and been able to assist the person in either something as minimal as, you know, medical or medication management, all the way up to finding housing. And that's where we're looking with it. It's not a done deal yet, but that's the idea. And it does look to be a pretty substantial amount if the department ends up paying all of the assessed contempt funds.
Interesting. Well, yeah, I'm sure it's a substantial amount, because You know, I've been off the bench for more than 2 years, and it was at least my last 2 years that we were assessing fines against the department, and fines that went, you know, higher by the day. So I bet it's a lot of money.
It's quite a bit.
Yeah. Okay, well, it's a start. And you know what? If there's extra money, think about pretrial services.
I mean, we're trying to target
The protected class should
Yeah.
be the beneficiaries, right?
I understand, although pretrial services would benefit the protected class also, but I understand. Well, cool. That's good.
I mean, just by analogy, I can tell you, and I'm sure Maya can say the same. We routinely see people that have spent a year waiting for, you know, getting to restoration. They have not been competent to stand trial. They have not been competent to assist in their defense. And after a year, we finally get them stabilized enough that they're competent for trial purposes. We get a quick plea, quite frankly, and then they're left on their own at that point and destabilize very quickly sometimes. And so our hope is having some options out there for people that really need it. This isn't meant to go in and take people's liberty away that don't need this, but the cases where there truly is mental illness, that the second they're out of custody, it just destabilizes again and they are right back in the system. Those are the people that are being harmed the most in these cases, and those are the people that we'd like to target. So
Yeah, I'm really curious when you're ready to tell us like how you will identify the people that would qualify for this. And you know, I mean, we bring the contempt motions. The defense brings contempt motions because our clients are suffering, and our hope is that it would push the state to admit them quicker. It doesn't. It does not have that effect. But we continue to bring them. And I think depending on how it affects our clients would affect, you know, whether we continue to bring them or not. So I think it's like we need to know what is going to happen to that money and how it's going to affect our clients. And because it would inform whether or not we would want to bring contempt. I mean, the court can certainly sua sponte do it, I suppose, you know, but whether the defense, you know, what we've always been the ones to bring those motions. And I think we're the ones pushing to say, what are you going to do with these monies? And can we get judgments? You know, it took us trying to get judgments for the court to finally start issuing them. So I hope that we will continue to be involved in the discussions around it, because I mean, otherwise the court could do it on their own, I suppose.
yeah, I mean, like I said, this has been in development for quite some time with the court. It was not something that we were ready to make public as of yet, and it's still not set. And I think it's going to take community participation as far as who will actually be filing these and how we set that up. And at a certain point, I think the court, due to separation of powers issues, needs to step aside. I think really this is going to be us getting the ball rolling towards a certain goal, funding, having the money go towards like you said, Maya, we would like this to see this go towards the protected class, the parties that are being harmed in this, and then stepping back and let either the executive branch or some sort of community participant take over. That's the goal, and we're still early on in this, and Judge Garrett, I'm sorry, Judge Brockmall should be able to provide a little bit more information as to where we're at currently, but it has been in discussions for quite a while. And I know that's not fully pre-trial, but it is somewhat, because I mean, these are the folks that are waiting in the jail to be transported, and that's where the contempt funds come from, and that's who we're hoping benefits from them. So
Can I just make one comment that bears on nothing, I suppose, but I've always wanted the defendant involved to get some benefit directly from those funds. After all, the defendant is the person who had to live with the hell of mental illness in a jail environment. And oh my Lord, I mean, talk about suffering. So it sure would be nice if some of the funds could be set aside just to help people. I mean, people who are under guardianship to, I don't know, help them pay for their meds or help them
Housing.
pay for their food or find housing. I tried that years ago with the first case in which I had issued an order and judgment for funds when the department didn't evaluate somebody, and the guy ended up being in jail for several months that he shouldn't have been in jail. And I set up a trust fund for him with the money that the state finally paid, to my surprise. That was really impractical, as it turned out, and I guess kind of naive on my part to think that would work on a one-on-one basis. But I really wanted the guy to get some of the benefit that had some of the financial benefit that had come from the fact that he was the one who had suffered through these days in jail. So anyway, it's not practical to do it on an individual basis. I soon learned when we set up a trust for this guy. But in some sort of systemic way, it sure would be nice to see some of those monies going to the people involved.
And that is absolutely part of the discussion. It's just that it would have to be separated from the judicial side. We couldn't be managing that part of it. That's why it would have to be through some sort of guardianship or something of that nature. So
Interesting that it would be the department doing the guardianship and the department paying the funds.
I'm not certain it would be the department. I'm just saying it would have to either be a third party. We've seen it.
Somebody, yeah.
Using it at times.
Yeah.
To insinuate that they'd be the ones actually filing it. We've just seen some success in at least a couple of our departments where that has occurred. And
Yeah.
been able to get stabilized and don't want to leave the situations that they're in, even when their condition improves sometimes.
What I did was appoint a private attorney as the guardian for this, as the trustee for this trust to pay this individual defendant. And, it was a nice idea, but that's far too expensive. And, I'm on a one-on-one basis. And anyway, there are various ways to do it, but it would be nice to see the department not involved in, rendering the direct services. But above all, it would be nice to see defendants get some sort of compensation for what they went through.
Yes.
Yeah. Good. That's a good thing.
Judge Freeman, there is a side work group, much like this work group, looking at competency restoration issues. Maya's on that. I'm on that. I think County Council Member Buchanan and Perry Mowry from the Health and Community Services Department coordinate that. Are some of Judge Grockmall's conversations with them as well? Because I'm not sure the executive is a part of those.
I don't think they are as of yet, and she was on that committee last time
Oh, that's right. That's right.
but I don't think they have been with the committee yet. Like I said, there are reasons why we had to keep it amongst the judges for now. And then I got to a point earlier this week where Judge Crackmall and I had a conversation, and it felt like a good time to at least introduce the topic. And so I was going to reach out to you, Stephen, actually, to have something set up maybe with the behavioral health, or I don't know if we're ready to bring it to the task force level, just to inform them of what's going on. But I will probably hook you up with Judge Grockmall and let you have that conversation directly with her.
Okay. Maya, any thoughts you have on that also? Seems to me it ought to filter up to the task force eventually, but not quite immediately.
Yeah, I'll keep my ears open.
Okay.
I apologize. I didn't mean to hijack the work group with that side topic, but
No, that's fine. Did you hear what I said?
No.
No, I realized my phone was muted, I think. This is Judge Garrett, and my question is, have we taken things as far as we can so far? And do we need to meet again in a month, or should we defer a meeting until early November? Early October is fine with me, but I'd like to know what the rest of you think.
I think if we waited 2 months would be okay. So in the meantime, I know I've been kind of a silent partner and watching today, but I'm going to try and meet with Lieutenant Erickson about data collection. I know Andrew's already well on top of that, but I want to see about being able to merge kind of our systems to be able to share some information, some important data that might help in tracking, I guess, crime statistics, if there's any other way to say that, and how long that people are being left in custody pretrial versus now versus when we started, like in 2019, when our numbers were a little bit bigger. Also, as Judge Freeman mentioned, I'm in the process of kind of revising the county website. Not so much. I've already talked with Heather Britton about it, about how much access she has to it and what she would like to see on there. And she was going to start sending me information that she would like to see on that website that might be beneficial for public transparency, ease of use, information, just a better information source for public. And along with that, I've been speaking with Arden Haynes and somebody in IT about how to start a Facebook page, and what the legal, I guess, problems could come of using like the Facebook Messenger to contact my clients or to contact just people going through the court system right now, just in general, maybe not just my clients, but everybody using Facebook Messenger for that feature. And Arden's sent me some information that I have to review and kind of keep Dave in the loop of, Dave Reynolds. So in the meantime, I'll work on those things. It's kind of long, tedious work because it can't just happen all of a sudden. We can't go live on a Facebook page, or I can't make adjustments to the county website without proper permissions. So that's what I'll be doing in the meantime.
That sounds good. I'm really glad to hear of your work on, getting as much of pretrial services onto limited social media as possible, because that's how people communicate these days.
Yeah, and in general, I think there's kind of a stigma or a misconception around pretrial services, that we're heavy-handed, or that we're only here to turn people into the court or to file violations, but really we're after the same thing that the public's looking for, is guidance to get people to services, and I've been sending as many as I can lead referrals to, Tom over there, and Adam Fryer. And so
Good.
I like having that opportunity to do that. But on the flip side of it, there's also the court, and in general, we're here to also let people know their court dates and to report any law, law violations. And so together, like all those things are all part of pretrial services. And so I just want to also kind of post our mission, vision, and values that we could review as a committee on the website too, to kind of let people know what we do.
That's a very good idea, because you're right. People see the sort of law enforcement side of pretrial services, and that's part of it. But pretrial services is set up to help its clients succeed, and people need to know that too.
Alan, just as technical background information, the county council has had a contract for communications, messaging on behalf of the task force with Pyramid Communications. That's running out at the end of the year, but they have helped us have a Facebook presence, a social media presence. Mostly it's community education about the work of the task force. but there's been a lot of the groundwork within county IT about setting up Facebook and using social media. And I think if you talk to Jill Nixon, and Jenna may even have been hands-on with some of that also. So there's probably a lot of approvals already in place and some work on developing that. And I think that could be shifted over to the kind of social media presence you're talking about as well.
Thank you.
And on the website side, Alan, just keep me in the loop as well, because we're also having to develop a website with the water adjudication, and I'm working with AOC on that, and I might be able to provide some. There might be some spillover that we can. apply.
Excellent. Yeah, thank you.
So where are we on planning for our next meeting? Maybe we would do well to check in with each other in October with an eye toward skipping a November meeting unless we need to have it. What do you think?
Yeah.
Well,
Yeah, that'd be
silence is
okay.
deafening.
Sounds good.
Okay, speak now or forever hold your peace. We've got a plan. The first Friday in October will be our next meeting, 12:30, obviously. In the meantime, several of us have taken on assignments. I'll write a letter to Andrew's superior, and I'll work it through with Judge Freeman, and the court will get that out in an efficient fashion. And several of you took on conversations with the prosecutor's office about Maya, and Dave, you were going to talk with Eric Ritchie about working together on some of these SOCs. And Alan has given himself his assignments, and we'll look forward to hearing the progression there. Am I leaving anything out?
I will update everyone on the willful flight issue as well as it comes up.
Right, right.
And
And
the
everybody,
hiring process, if it moves forward.
Yes.
yeah, please keep us posted. And then the assignment that everybody gets is, if you haven't already, please read the article that Carol had Jill send around, because it gives some good ideas. Okay, and with that, I think if nobody has anything further, we'll adjourn the meeting. Does anybody have anything you want to say before we adjourn?
Do we have any public comment?
Thank you.
There are no attendees on Zoom or in the conference room, so no public comment today.
Okay, thank you for noting that, and thank you for remembering to ask, Judge Freeman. Okay, that finishes our discussion today. I think we had a good meeting and covered some interesting things, and I look forward to seeing all of you in the beginning of October.
All right, thank you.
Thanks,
Bye,
everybody.
Thank
everyone.
you all. Bye now.